Heleniston. I'm glad to see you here today. First, can we start with introducing yourselves, please?
I'm Laura Clement. I'm the one of the counsellors for Skag and Skull. This is my colleague Beth. She's also one of the counsel for them as well.
My name's Karishma. I'm one of the counsel for Aberdeen Distillery, and this is my colleague Veronica.
Well, before we start, I want to remind you guys about the rules. Have you decided any procedural rules that we should follow, like the minutes that you guys each should?
I propose 5 to 10 minutes for submissions.
Yeah.
If everyone agrees with that.
I agree.
Okay then, each party will have 5 to 10 minutes. If you guys exceed it, I will have to jump in and sorry for this, but let's start. First, I want to listen to the claims about the jurisdiction, and can the claimant go first? Oh, by the way, before that, you will have a chance to respond to the claims, and the claimant will have the chance to respond to the responses. So, be aware of this. Please don't jump into each other's words, and you're respectful to each other. Okay. Claimant, go first, please.
I'm here to assert that due to procedural defects in the dispute resolution clause of the arbitration agreement and the issue of validity of the main contract, tribunal does not have the requisite jurisdiction to arbitrate the given matter. Lack of jurisdiction can only be overcome by a fresh agreement between parties. The grounds for arbitration in respect to the current dispute are found in clause 10.2 pertaining to dispute resolution procedures of the draft framework agreement for the supply of whisky between Aberdeen Distillery and Skag and Skull. Now, there is some concern as to whether these drafts constitute a valid binding contract. As far as I'm aware, this contract was not finalised in either the preceding negotiation or mediation proceedings. In other words, my plea concerns the existence, validity and scope of the arbitration agreement. I implore the panel to safeguard against putting arbitrations into motion when no jurisdictional basis exists at all. Under the Swiss International Arbitrations decision, a case involving a license agreement provided that after the license expired or was terminated, some provisions of the contract would remain in force, but otherwise all rights and obligations of the parties would terminate. A dispute arose and arbitration proceedings were initiated. The issue became whether without a contractual basis for arbitration could it go ahead. I highlight here that it was stated that the existence of an arbitration clause cannot be accepted lightly. The agreement to resort to arbitration and to abandon the jurisdiction of the state courts must be clearly expressed. I should clarify that ultimately the arbitral tribunal accepted jurisdiction despite termination. However, the difference between the case and the present matter is that at some point there was a legitimate presiding contract. This matter concerning Aberdeen Distillery and Skag and Skull has been from the beginning disjointed and lacking legal effect.
I do have a question at this point. You are now coming to me with the claims that there is not a contract at all. It's not an agreed contract. It's not about the jurisdiction then. It's about the existence of the contract. Am I right?
Well, yeah, at the moment I'm saying that there's issues as to whether there is a valid contract, and I do believe that that should be raised. You finished your question?
No.
I was going on to say that, preempting what Laura might have to say, I'm well aware of the doctrine of separability or severability. According to Professor Alan Uzlek in his article he wrote for International Arbitration Law Review, the doctrine of severability is such that it has become widely recognised that arbitral agreements have a fate independent of the main contract. so that invalidity or termination of the main contract does not necessarily affect the validity and binding force of the arbitration clause.
But now we're talking about an arbitration agreement only. Are you referencing the first agreement that you guys?
Yeah, I was referencing the first agreement, and I was just saying that. Oh, sorry.
No, you go.
Okay, so I thought if you find it to be invalid, there's no jurisdiction at all for this arbitration to happen. If, on the other hand, you consider the main agreement severable from the arbitration clauses, then I was going to lead on to my second point.
Okay, please go on to your second point, because the first point has nothing to do with the jurisdiction.
Okay.
It's about the validity of the arbitration agreement and the consent of the parties.
Okay. So if the tribunal finds the root of my reasoning of this reason to be the correct one, so as you said, I would ask that you further consider my second point. My second point being that which has been proposed by Scargan Scout in Annex 1 does not correlate with what is set out in the main agreement, which as per the tribunal's judgment may or may not provide the arbitration agreement with its jurisdictional basis. Whilst the main agreement states that the matter shall be conclusively resolved under the rules of the London Court of International Arbitration, the place of arbitration being London and the language used English, Scargan Scout proposed that the arbitration be conducted under French law for the French courts and the legal systems well known per arbitration support at the Permanent Court of Arbitration. Essentially, the two are contradictory and hence defective. Namely, mentioning French courts and the legal systems to conflate arbitration with litigation of sorts. As stated earlier, the parties should be asked to reinstate a fresh agreement. Again, preempting that Laura may ask that the clauses in the agreement be interpreted to make arbitration possible. In making this assessment, I ask that the tribunal considers Hudat Parker and the Shipmill Hill, in which it was stated that where the parties had agreed on a foreign exclusive jurisdiction clause, there is a firm disposition in favour of maintaining that bargain unless strong reasons be adduced against a stay. The presumption only rebutted where exceptional circumstances are shown by either party. Such language would seem to preclude arguments of mere convenience as a basis for resisting enforcement of the clause. There's also the doctrine of pro-enforcement, which was asserted by Chief Justice Spiegelman in the appeal of Batchcock and Brown, in which it was stated, the law with respect to exclusive jurisdiction clauses should reflect important policy considerations, relevantly that parties should be held to their contractual bargains, and the resolution of disputes arising from contractual arrangements should occur in a coherent and consistent manner which is most expedient and efficient. Almost finishing. Hence, if the tribunal decides to validate the agreement to arbitrate, the seat of arbitration should be as per the main agreement in London, the proceedings held in accordance with the London Court of International Arbitration and the language English. This again depends on the tribunal's decision as to whether there is a valid contractual basis for the arbitration agreement. Finally, I would also like to bring to the tribunal's attention to the pathologies in the last paragraph of Annex 1. As you know, litigation and arbitration are not congruous. However, it has been earnestly stated that where parties are unsatisfied with the arbitrated outcome, English and Danish courts will have jurisdiction. Furthermore, the prospect of litigation is incorrectly conflated with the functionings of the World Trade Organization dispute settlement body. This clause is completely defective and unworkable.